Hi, this is Mike Young, estate planning and asset protection attorney in Walnut Creek, California, and I would like to explain to you what a pour-over will is. We get that question all of the time, what is a pour-over will? Before I proceed, click the subscribe button below so that you can get notice of future videos I create on estate planning and asset protection. So most estate plans in California are trust-based plans. That means that we create a revocable living trust for a single person or for a couple. And we transfer assets into the revocable living trust. For instance, let's say Bob and Mary Smith create a revocable living trust, and then they transfer title of their home to their revocable living trust. So Bob and Mary Smith, husband and wife as community property, transfer their home to Bob and Mary Smith, co-trustees of the Bob and Mary Smith revocable living trust. And then if Bob dies, the home stays in the trust for the benefit of Mary. And when Mary passes away, the home is distributed to the couple's beneficiaries, probably their children. So this is a trust-based plan, which is very typical in California. And by having a trust-based plan, Bob and Mary Smith have avoided probate. They have avoided court involvement for distribution of the home, for passing title of their home to their children. So the transfer of the assets can be a home and other assets, monetary assets in the trust. The transfer is done through operation of the terms of the trust without having to go to court. So no probate court is involved. Other types of estate plans are will-based, where assets are identified in the will, and the will says on the passing of the makers of the will, everything goes to the children. So let's say Bob Smith has a will and it says the house goes to his wife. Well, with community property, it would go to his wife. And Mary, his wife, in her will says on the second death, whoever it is, the children get the home. So then we have a probate. We have to go to court. It's very expensive. It takes about a year to go through a probate court proceeding in order for the home, in this example, to transfer to Bob and Mary Smith's children. So that's why a trust-based plan is very popular in California. I think in other states, probate proceedings are not quite as complicated. So when I prepare a trust-based estate plan for individuals, it can be a couple or a single person, I always prepare a will. So remember, will means court, but in this case, we're not going to go to court because we have the trust, but we have a pour-over will. So the pour-over will, which is rarely used, the pour-over will says, for instance, with Bob and Mary Smith, let's say Bob dies, everything stays in the trust. Let's say Mary is left, and then she dies. And when the family is looking for assets, we find that Mary has a bank account of $200,000 that was not transferred to the trust. And maybe there is no pay on death beneficiary named in the bank account. So this has happened before, not too often. So what we do with the pour-over will, if no beneficiary is named, we have to use, and it's not in the trust, we have to file the pour-over will with the court and start a probate proceeding. So the probate in this case is easier than a probate where we don't have a trust, because the will says if I die, and there's an asset. I want that asset to pour over to my revocable living trust. So we file the pour over will with the court and petition the court for a decree of distribution, transferring the $200,000 into the revocable living trust. So the probate court proceeding is easier because we are dealing with fewer people, basically the trustee of the revocable living trust. So we get a decree of distribution pouring the $200,000 into the revocable living trust, and then by operation of the terms of the trust, the $200,000 is distributed to the beneficiaries of the trust. So as I mentioned, a pour-over will is not used that often because this scenario does not come up that often, but the pour-over will is a safety net that I believe is very necessary, because this scenario does come up on occasion. If there is no pour-over will, then we have to probate the estate, for instance, for Mary, of the $200,000, give notice to heirs, and go through an entire court proceeding, which could take an entire year, etc. So my name is Mike Young, estate planning and asset protection attorney in Walnut Creek, California. And my website is walnutcreekelderlaw.com. And take a look at the website. If you would like to call and talk to me, my information is in the website, walnutcreekelderlaw.com. So thank you very much for listening.